This morning we had what I will call a part 2 of the bond hearing for Ms. Strotman. This was a kind of an appeal from what happened in our Henrico Juvenile and Domestic Relations Court. The law allows one to appeal from the General District to the Circuit Court. We were here before Judge Wallerstein several weeks ago, and the matter was continued to this date to allow for what was discussed in open court at that time for an evaluation of the defendant. So we were back here today, and there were some preliminary conversations that occurred in chambers with the judge and counsel, wherein certain issues were discussed. And then we, of course, came back out, and on the record, you heard that all of the evidence that had been presented last time was, of course, adopted for the continued argument today. There was reference to the report that had been submitted by defense counsel, had been received by the court and by the Commonwealth and reviewed for today's hearing. And there were certain representations made regarding that evidence without going into any details for fear of wanting anything to be relayed that could be deemed to be prejudicial to somebody who is innocent until proven guilty. And then the court went through the law and talked about what the law of Virginia allows for when considering whether or not one can be released on conditions. And that's what we heard Judge Wallerstein outline today.
Can you just share what those conditions are for people who weren't in there?
Sure. So the first thing is that a court can take in consideration what we call a bond, a surety bond, which is a monetary value, and the court did put a parameter of $12,500 per charge, so for a total of $25,000. That is a bond that will have to be posted. In addition to that, the defendant, it was represented, would be living with her parents and was going to be on a GPS monitor, meaning that all of her movements would be monitored per what will be done through the sheriff's office. There were also conditions placed that was prohibiting her from engaging in certain jobs, as well as prohibiting her from having certain contact with minors.
I want to go back to the report, because earlier in court we did hear that there were talks about text messages and things having to be sealed.
That is correct.
To a Mr. Gunn.
That is correct.
Go into detail about that?
Well, again, those representations were made to the court, and again, making the reference to have them placed under seal, because we do not want the specifics of those references getting out, and again, somehow perhaps prejudicing a jury or prejudicing any type of fact finder before the time of actually having a trial. But that is why we are allowed to employ a procedure that is called, going into chambers, which is just essentially saying that we went back with the court and made certain representations that are confidential, but are things that he is allowed to consider. So the text messages, of course, were under seal, and the report itself was under seal. So therefore, the judge is allowed to acknowledge those facts, but those are items that are going to be kept from the public's eye.
Are these additional texts, or are we talking about the texts that were
The same text messages, that's correct.
Have they already been out in the public? The media has reported on them?
Well, what the media has done with the text messages and how we are handling ourselves in court are kind of two different things, two different processes. But what I will tell you is when we talk about kind of high profile cases, and if we do have this matter being brought before a jury, right, people from Henrico County, we always ask about if people are aware of the case. Have they heard about the allegations? Have they heard or seen certain details? Because again, the idea is that whenever we're going to present this matter to a jury, we want to make sure that the citizens are free from any type of influence, so that a defendant has their constitutional right to a fair trial.
Do you feel like maybe you erred in talking about the text messages at the last hearing?
No, there's no error because when we talk about, communications with individuals, obviously anything that we talk about now regarding social media, text message, Facebook, anything of that nature is really kind of commonplace now in our society in how we communicate. So no, without going into the specific details or having the actual context to be published, we believe we achieved our goal.
So the text messages and the medical report, two separate situations, but they are both being sealed for the possibility of prejudice.
That is correct. That is correct.
Share any generalities about the mental health evaluation?
Just that an evaluation was completed and there was an opinion made by the provider, and that was something that was submitted to the court. And I believe that Judge Wallerstein said that he had read the report and he did take that in consideration with all of the other factors that the law provides.
Does she have a mental health condition?
That is not something we're at liberty to talk about, but certainly the court was mindful of understanding what representations were made into a report, and he took that into consideration in coming forth with the conditions.
Same with if she has a drug problem?
That is correct. And of course, we know that one of the conditions that the court did provide is when we are saying that somebody is to remain, homebound on a GPS monitor and only allowed to leave for certain purposes, medical visits are included in that. And of course, those will be medical visits that I think even the court was clarifying are done with verification. So the pretrial entity here in Henrico Court will be overseeing her movements, will validate the representations of why she needs to leave, and will keep track of that.
Do you really think you can find a jury that is unaware of this case?
Sarah, you'd be surprised. We have had plenty of high-profile cases here in Henrico County, and I am always very grateful that we have good citizens who keep an open mind and what I think is provide fairness for the judicial system.
Were you still contesting bond today? If yes, are you comfortable with what just happened in there and that Erin Strotman will actually be released and going to her parents' house?
Well, the Commonwealth maintained the position that we were objecting to any conditions of release. We believe that with the nature of the charges, with the nature of the strength of the Commonwealth case, those are considerations, of course, factors that the court did take in consideration, that we believed that the actions were so egregious and the strength of the Commonwealth's case is so strong that we did not believe that there are any conditions to ensure safety to herself or safety to others. The court, of course, is our neutral arbitrator and has the law, and he was very purposeful in going through the factors. And so we do, we understand why the court, said what he said. We just, of course, were advocating for our position that we believe that she should be held. And then, of course, it is incumbent upon our pretrial office to make sure that they are reviewing the defendant's whereabouts and her release. So they know that they have a job to do too. Then they are to immediately report any violations to the court.
It just felt a little loosey-goosey, like the parents stood up, they took an oath saying they'd get rid of their guns. How can you guarantee that there are not weapons in that home?
Well, we do this. You all may have heard of the red flag procedure, and that's when we're talking about people who are in crisis, and we have a criminal procedure, a due process procedure that allows for a court to hear about, generally speaking, about somebody's concerning behavior. And the court in those cases can also order firearms to be removed from a home. That is why I stood up and said to the court, Your Honor, since this is a provision that you have said, can we make sure that we can follow that same process? That is why the court asked the parents to stand up. They have now sworn under oath that yes, they do have firearms, and yes, they will be removed prior to their daughter coming to their home. And we will ensure that that will be followed up on either through CCP or even with the locality, the law enforcement locality of where she will be residing.